Thanks. Hello, everyone. Welcome to today's extremely timely JINSA webinar on the legal challenges to IDF operations in Gaza. I'm Jonathan Ruhe, JINSA's Director of Foreign Policy, and I am fortunate, as always, to be joined by two longtime friends of the organization and great contributors to JINSA's work, and most importantly, experts on today's topic. Marc Warren is a JINSA Distinguished Fellow, and he is counsel at Adams and Reese, LLP. He is also a former U.S. Army colonel, including serving as a senior legal advisor to the 101st Airborne Division and to Joint Special Operations Command. Jeff Korn is also a JINSA Distinguished Fellow, and he is the George R. Killam Jr. Chair of Criminal Law and Director of the Center for Military Law and Policy at Texas Tech University School of Law. Previously, he served in the U.S. Army for 21 years, retiring as a lieutenant colonel, where he served, among other things, as the Army's senior law of war expert advisor. Before we delve into today's webinar, I want to flag for our audience that both panelists are members of JINSA's Gaza Assessment Task Force, which will soon be issuing its new report assessing the operational and military legal dimensions and implications of the ongoing conflict in Gaza. Today, we'll be discussing recent legal actions challenging Israel's military operations in Gaza. This morning, the International Criminal Court, or ICC, issued arrest warrants for Israeli Prime Minister Netanyahu and Defense Minister Gallant, citing, quote, war crimes and crimes against humanity, end quote. This comes slightly more than a week after the U.S. State Department issued a report assessing that Israel has violated international humanitarian law. And more broadly, in recent months, we've seen the International Court of Justice, or ICJ, dealing with claims brought before it of genocide regarding Israel's conduct toward Gaza. Before we jump in, I'd just like to remind our audience, you can submit your own questions via the Q&A box at the bottom of your screen, and we'll do our best to deal with them all in turn in the time we have today. And so with all of this in mind, there's obviously a lot to unpack here. I'm going to start with very broad questions, and we'll drill down into some of the more specific permutations as we go along. So Marc, I'd like to start with you. Again, start with a very broad question. What was the ICC set up to do? And I want to give people a sense of, we've heard about the ICC in the context of Israel a lot, but I think it'd be helpful for all of our audience members, if you could explain to us just what is the role of the International Criminal Court and what sorts of things does it, is it intended to do on a day-to-day basis?
Yeah, so thanks, Jonathan. First of all, it's a pleasure to be here and to be among friends. The ICC was established by the Rome Convention, often called the Rome Statute, to be a permanent tribunal to look at violations of international humanitarian law, building upon the record of ad hoc tribunals that existed in places like the former Yugoslavia. It was immediately controversial for a number of reasons, including concern that it would actually perversely and ironically exercise jurisdiction over individuals of nations who actually strive to comply with the law of war, have excellent law of war programs. And for that reason, by statute, the United States has taken the position that we will not allow our military forces to be subject to the jurisdiction of the court. This claim or this request for indictment today really demonstrates everything that's wrong about the ICC. Fundamentally, the ICC was designed expressly to deal with those countries who didn't have adequate capability to investigate and prosecute violations of international law themselves. And this principle of complementarity is something that is very odd about this from an objective standpoint, because Israel, like the United States, and by the way, Israel is also not party to the convention, has a very, very robust internal mechanism to deal with allegations of international law, to investigate, to hold its military forces and members of its government to a very high legal standard. So for the ICC to exercise potentially its jurisdiction over Israel is frankly shocking, but unfortunately not unanticipated. Again, the United States anticipated the court would try to exercise jurisdiction over our forces. Congress has blocked it. And for years, special interest and non-governmental groups have tried to get the ICC to issue indictments and warrants for Israelis and have thus far been, until now, unsuccessful. I would add, unless your information is more current than mine, Jonathan, I don't believe arrest warrants have been issued yet, and you or Jeff could correct me. My understanding is that the prosecutor has announced that he's going to ask a 3-judge panel of the court to indict. Then, based upon the indictments, there could be arrest warrants issued.
Yeah, thank you. And if I use my terms loosely, I apologize. And Colonel Warren helpfully clarified that. Just a quick follow-up question. In terms of ICC officials themselves, are they what the Rome signatories to the Rome Statute agree to, I guess, abide by the ICC, but sort of these pursuits of indictments, are these ostensibly independent legal officials? Who forms the court that then issues these legal proceedings?
So they're not necessarily independent legal officials. I mean, they're supposed to be, but I would say that they are as independent and unbiased as other members of various UN operating organizations and entities. And we've seen, or frankly, as the ICJ, that we have seen that different people come to the court with their own bias and their own agenda. And unfortunately, that is a reality in international organization. I mean, I'm curious about Jeff's reaction to this, but I mean, I think all of this has to be viewed through a prism of politics and preconception, maybe even, unfortunately, preordination. And as I said, this is shocking, but to me, it's unsurprising. I would add one other thing, and that is it's also sadly in furtherance of the strategic objectives of Hamas to delegitimize the IDF and the Israeli government, to shame, to embarrass the Israeli cause, to undermine international support for Israel. So this is a page in that playbook.
Thank you. And I'm glad you raised that issue of the focus on Israel here. That's something I want to delve into in a bit. And just for a quick clarification, because we're going to be using ICC and ICJ back and forth in this hour, the ICC is set up to prosecute individuals, and the ICJ is set up to adjudicate claims between nation states. Is that correct?
Yeah.
Without being oversimplification?
Yeah, that's a thumbnail, state versus state, and then ICC and international humanitarian law versus individuals.
Excellent, thank you. So Jeff, I'd like to turn to you now. So in the ICC's, what we heard today, they throw around terms like war crimes and crimes against humanity. What is your assessment of? Do we know how they sort of came to that assessment? Because those are pretty heavy accusations to throw around.
Well, I mean, they're not throwing them around. The prosecutor is invoking provisions of the Rome Statute. The Rome Statute includes the crimes that were adopted to fall within the jurisdiction of the ICC. And interestingly, the United States played a significant role in developing that list of crimes, because initially, I think the United States was inclined to support the court. The real stumbling block for us, ironically, was the insistence of the complete independence of the prosecutor. The United States felt it was important to give the Security Council the opportunity to basically shut down a prosecutorial effort, because ultimately, international criminal accountability influences not only the accountability of the individual, but it also influences the restoration of international peace and security. And interestingly, the tribunals that my friend Colonel Warren mentioned for Yugoslavia and Rwanda were adopted or created pursuant to the Security Council's authorization and authority to impose measures for the establishment of international peace and security. So the United States took the view that there could be situations where the zealousness of a prosecutor was so aggressive that pursuing the case might actually undermine efforts to achieve international peace and security. And boy, does this seem to smack of that concern, right? We're in the midst of complicated negotiations. I mean, I listened to former Secretary Panetta yesterday on the news say, what we need is a ceasefire and a return of all the hostages immediately. Well, people make it sound like somebody has control over Hamas. I'm sure that if Hamas said, we'll give you back all the hostages tomorrow for a temporary ceasefire, the Israelis would do it. But one doesn't necessarily beget the other. So this is a complex negotiation with a really nefarious armed group and organization. And now into the middle of all this is injected this zealous prosecutor who seems obsessed with demonstrating equality of condemnation. You may remember, Jonathan, that one of the first op-eds I wrote after October 7th was titled "Equality of Obligation Does Not Mean Equality of Condemnation." That both sides are obligated to follow international law, but there's no requirement that we condemn both of them equally. You could see what was coming. And there seems to be an obsession with this. The fact that he has to announce the pursuit of the arrest warrants on the same day he's going after Hamas, suggesting a immoral equivalency, if you will. You know, the reality here is that he's probably going to get the arrest warrants. The pretrial chamber is probably going to grant them because getting an arrest warrant under the ICC treaty is not that difficult. It's really no different than a police officer going to a magistrate in any city of the United States saying, I've got probable cause to arrest somebody. Can I have an arrest warrant? The standard is very low. In the ICC statute, it's a reasonable basis, but it means about the same thing, that there are facts and circumstances that justify a reasonable belief that violations of the Rome statute have occurred. The problem is that there is an expectation, as Colonel Warren noted, of an exercise of discretion, and that the prosecutor of the ICC not seek to pursue people because of who they are, but to seek to really go after individuals who are in a system that award them absolute impunity for serious violations of international law. I don't know how you get there with Israel. The Israeli Attorney General is completely independent of the government, and the Israeli Attorney General and judicial system have prosecuted and convicted prior prime ministers. So the suggestion that Israel is incapable of investigating and imposing accountability, if it were to turn out that there was credible evidence that Benjamin Netanyahu and the defense minister were complicit in a plot to intentionally starve civilians or to intentionally attack civilians, it's just not credible. I know I've gone on a bit, but I want to read something to you that it just is so profound at this moment. One of the great American Supreme Court justices in history was Robert Jackson. Robert Jackson was appointed by President Roosevelt after he served as Attorney General of the United States. He was also put on leave from the court to be the chief prosecutor at Nuremberg. He knew something about prosecutorial discretion. And in 1940, he gave a speech to the U.S. attorneys in the Great Hall of Justice when he was appointed Attorney General. Here's what he said. If the prosecutor is obliged to choose his cases, it follows that he can choose his defendants. Therein is the most dangerous power of the prosecutor, that he will pick people that he thinks he should get rather than pick cases that need to be prosecuted. I mean, my sense of this is that this is a prosecutor who's dancing to the drum of public outrage, much of which is poorly informed and exaggerated, and the product of a deliberate disinformation campaign by a nefarious and barbaric entity. And he feels this compulsion to show the equality of this criminal process, but you don't target people as a prosecutor. You target crime that deserves to be prosecuted. And I think this is the great tragedy of this incident, and it will harm the court for a long time to come and basically affirm the worst suspicions that the United States had that led us to abate the decision of whether or not we would ever become part of it.
Thank you. I will turn to the sort of the direct U.S. implications, U.S. related implications of what we're seeing here regarding the ICC. So I just, a bunch to get to here. So Colonel Warren, to jump back to you, we've talked about, the ICC's authority and where its jurisdiction may or may not apply. If there are arrest warrants issued for Prime Minister Netanyahu and Defense Minister Gallant, in terms of tangible implications, what does that mean? Is that as simple as if they travel to a country that's a signatory to the Rome Statute, then they're liable to arrest and prosecution, or where does if there are arrest warrants issued, where does it go from here?
Yeah, so possibly. I think it depends on the country that they visit, and not just whether they're party to the Rome Statute, because again, there's a political dimension. Obviously, the ICC has no marshal's service that it sends to Israel to execute the arrest warrant. I think, and in no way to put the people we're talking about today, except perhaps the Hamas individuals who face indictment, but certainly in no way to compare the Israeli individuals. But Putin is a good example that Putin has been indicted. There has been an arrest warrant that's been issued against him. Obviously, there's no one to serve the warrant. It hasn't been executed. And it has arguably affected his ability to travel, but it really has affected his prosecution of the war in no way. I think as a practical matter, the effect is more informational. It's negative, it's perverse. And I think a point that Jeff raised is, as always, a great one. And that is the idea of equality of obligation and equality of application. It's almost as if what the Hamas individuals have done is totally beyond the pale. And in fact, that it is, no question, barbaric and so on, as Jeff said. But it's odd to me that given that, the prosecutor would feel compelled to demonstrate his objectivity and his fairness by seeking indictments against the Israeli leadership. And to me, again, it plays into the objectives, the strategic objectives of Hamas. It plays into some of the things that we see going on in college campuses and on television. And that is this idea that there must be commensurate or coordinate responsibility for what's going on. Both sides are responsible, and it's concerning. And I know you're going to get into it later, but the implications on the United States when we have to conduct military operations are significant. And for those who said concerning, in my view, those who said concerning the U.S. position vis-a-vis the ICC, that we were overly reactive, we were overly protective, we were hysterical about the kinds of things that the ICC could do, we were right.
So this is triggering a lot of different questions I'd like to propose. I think, so one is we've heard about, obviously the focus here is on the targeting of Israel. They've also issued a warrant for Vladimir Putin's arrest for obvious reasons. Are there, Colonel Warren, I'll ask you this first. Are there, notable other examples of the ICC where they've, issued warrants for war crimes, or on the flip side of that, notable omissions you can think of that, would sort of lend more credence to this point that we've been raising since the beginning, which is, some of this is motivated more by general public opinion or is reflective of it. We've heard about there's disproportional focus, we might say, on Israel and not on Hamas. But can we put this in a broader context, perhaps more globally, in terms of things the ICC has chosen to prosecute or focus on versus notable omissions in the past?
Well, I would defer to Jeff as far as who has outstanding arrest warrants. I don't know. I will say, though, that the court has been criticized by some for looking too much at, if this is a term I could use, third world conflicts and third world individuals, and less at first world conflicts and first world individuals. Putin would be a spectacular exception to that. But that being said, the problem is that the vacuum of law, the vacuum, not a vacuum of law, but the vacuum of investigative capability and robust prosecution typically exists in those third world countries. It doesn't exist, as Jeff pointed out, in Israel. It doesn't exist in the United States. So it's odd that in furtherance of that criticism, that the ICC would choose to seek indictments against the Israelis. But Jeff, I don't know. I don't know who else is on the list of folks who are indicted or for whom arrest warrants have been issued.
Well, obviously Putin, but you're right, sir. Up to that point, the widespread view was that the ICC had become an African war crimes court. And so there was this kind of growing pressure, again, for equality of condemnation, that you have to find some developed nation that's engaging in hostilities to be able to allege certain war crimes. I think the Israelis have been worried about this ever since the ICC began its investigation into the West Bank and what was happening there. Having said all that, I think we have to be also careful. I don't like what's happened here. I'm highly discouraged. I mean, I've been emailing friends today saying I'm ready to just pack it in and just do criminal law from now on. None of it makes sense to me. We have to see how the process plays out. We may get surprised. The pretrial chamber may say, wait a minute, we're not satisfied that the evidence is sufficient, compelling. All of these crimes, it's not just the outcome that is prohibited. As a matter of fact, almost all the crimes are defined as what lawyers would call conduct crimes and not result crimes. And why is that important? Because what we should be focusing on is whether the conduct that produced a result was set in motion by criminal intent. So one of the charges is using starvation as a method of warfare. That requires proving an intent to starve the civilian population, not a collateral consequence of starving the civilian population. Not that it was reckless not to worry about the civilian population. That's not enough for the crime, for the war crime. It may be enough to prove a violation of the regulatory provision, but not enough for the war crime. Intentionally directing attacks against civilians or intentionally killing civilians. What you have to prove is that the defendant acted with that criminal intent. That's a high bar. Now, that doesn't mean you need an admission. You can prove intent through circumstantial evidence. But the absurdity of suggesting that the circumstantial evidence is sufficiently compelling, being the result that civilians died or civilians are malnourished, in an environment like Gaza, when you're fighting an enemy like Hamas, is perplexing. So the pretrial chamber may look at this and say, why are we going to approve an arrest warrant where you're never going to get close to proving guilt beyond a reasonable doubt? I mean, we're at a very low standard. Beyond a reasonable doubt means you have established that there's only one plausible conclusion to draw from the totality of the evidence. And that is that the Israeli leadership acted with an intent to kill and starve civilians in this campaign. I mean, I know I'm biased. I'm the first one to admit it, but I just don't see it. Having said that, you asked earlier, how do they come to these decisions? The ICC prosecutor actually commissioned a group of experts in international law to write a report for him on the potential of violations of the statute in Gaza. I got that report this morning from a friend. And some of the people who were part of that, and they, by the way, agreed that the evidence was sufficient to reasonably support an accusation of starvation as a method of warfare. And I know some of the people who are involved in that, and I have great respect for their understanding of international law. If you look at the list of names on the report, there is not one person on that list who has any military experience, any experience in conducting military operations. It's stunning to me. Now, again, I'm not suggesting that these people are not competent to give an opinion on international law. They're probably far more competent than me. But when you're looking at the complexity of an urban campaign involving 100,000 ground troops on one side, 40,000 on the other, in the most densely populated space on the earth, and you're reaching conclusions on the inferences you can draw from the effect of combat without even considering the views of people who've experienced that, I find that deeply troubling. And maybe the pretrial chamber will see that. I don't know. So as frustrated as I am, I want to at least acknowledge that there's more process that has to play out here. I'm not optimistic. I think the warrants will be issued. But then there's, the motion to dismiss, and then there's the trial. There's a long way to go here. The real problem, Jonathan, as you know, and as everybody listening knows, is that once the toothpaste is squeezed out of the tube, you can't put it back. And this is going to be taken as validation for everybody who said Israel is evil and immoral and illegal, and this campaign is a crime against humanity and genocide, no matter what the outcome is. The outcome of the genocide case, the outcome of this case. And that's what bothers me the most, that a prosecutor, why now? Like, why now? Why do you have to announce this now? Why not just abate the investigation into the Israelis? Go after Hamas. That's a clear-cut case. Let the process continue. And a year from now, when the proverbial and literal dust is settled, if you think there's impunity for war crimes, make your move. The way it contributes to the public outrage and condemnation, in my view, is undermining the efforts of good-minded people to actually try and achieve a credible resolution of this conflict.
Yeah, Jonathan, could I comment
Please.
on that?
Of course.
Yeah, so there's an old saying in the American law that hard facts make bad law. And there's no doubt that what's going on in Gaza is bad because combat is bad. Urban warfare is bad. And by bad, I mean that people are killed and they're not all combatants. Civilians in a densely packed area are killed and hurt, and we wish that wouldn't happen. But the report is a good example of this inference on effects that is very harmful for the United States or other forces that would have to fight in the future, potentially would have to fight in a densely populated area where there's no way around civilians, and there are going to be civilians who are killed, despite every zealous oversight measure and every targeting consideration that they will be killed. And so this whole thing is unfortunate for the United States and Israel and other countries that really look to their adherence to the law of war as something that is a guiding principle. The other thing is the prosecutor has really put the court in a bad spot, because I share the same hope that Jeff does. I also share the same reality, which is I would hope that the panel would say there's not enough, at least for the Israeli indictments. We're not going to do it. I think there's plenty for Hamas. But unfortunately, by asking for both and this desire to achieve some kind of equality of application, the court is going to be faced with, if they don't indict both, a tremendous amount of criticism if they just went with Hamas, which frankly would be the objectively correct decision, that now they're going to commit themselves to receiving, and the court receiving, a lot of complaints and a lot of condemnation. It would have been far better, as Jeff suggests, had the prosecutor simply waited and not done anything.
So thank you, Marc, for that comment. And that sort of leads directly into a follow-on question, which we've gotten from our audience, which maybe it just a little more way of putting it squarely. So if given all of this and what looks like sort of the motivations in issuing this condemnation of Israel at the same time as Hamas, and not, as Jeff said, waiting until the proverbial and literal dust settles, then what good is the ICC, and what do we care? Is this the type of thing that could fundamentally undermine the perceived legitimacy of the court, and work at cross purposes for the purposes it was initially set up to carry out?
Well, listen, I think that's a much more difficult question for some of our close allies. Plus, it's not as hard because we're not a member of the court, so it's pretty easy. The president and the Secretary of State have already aggressively condemned this decision by Khan, and that's not hard for us to do. And Colonel Warren knows when we were together in Germany, he and I would go around to other countries that were part of the ICC as part of teams negotiating exemption from the ICC jurisdiction for our service members who might be in their territory conducting training: Romania, Bulgaria, Poland, Hungary. But if you're a member of the court, you can't do that. So I think that question is really challenging for countries like the United Kingdom, France, and many of our NATO allies. They have a decision to make here. They have to decide whether they are going to be silent or whether they are going to assert opposition to this exercise of jurisdiction. And remember, a treaty is just that. You're not bound to it for life. I mean, how this plays out may undermine the credibility of the court so significantly that states choose to withdraw from it. And again, I remember when Khan was on the border of at the Rafah crossing early in their conflict, and he made a statement. And I remember talking to Blaise Michtel, and I wish him the best while he's over in Poland for his dad's funeral. But I remember when I spoke with Blaise, and Blaise said, "Have you seen the statement by the prosecutor?" I said, "I thought it was pretty credible." I mean, he talked about Israel's robust legal oversight system and the fact that they have a credible system for investigating. It sounded to me like his focus was pretty singular. So what changed? What made him so convinced that it was worthy to pursue at the same time crimes against Israel and Hamas? By the way, I've seen the list of the allegations, and some of that's also perplexing because he doesn't allege intentional attack on civilians by Hamas. They fired over 10,000 rockets at Israel trying to kill civilians. So again, Colonel Warren mentions the danger of this effects-based approach to assessing war crimes liability. Is there some view on the part of the ICC that if you aim a rocket at civilians and try and kill them and you fail to do so, you haven't committed a crime? That's a war crime. And so it seems to me that they're obsessed with the consequences. And by the way, some of those consequences we know now have been exaggerated. The UN itself has halved the number of women and children killed in the conflict. It seems that they're being driven by that, or maybe it's the bombastic statements of some of the members of the Israeli cabinet, and those have been problematic. They're their own worst enemy sometimes, and that's the consequence of democracy. It is what it is. It's a coalition government. You're going to have those moments. But I think, Jonathan, the long-term viability of the court and whether it can achieve its intended outcome, this is a stress test. How this proceeds, I think, is a genuine stress test. And I would hope the president and the Secretary of State would put, I don't know if pressure is the right word, but encourage our close allies who are parties to the court to express their disappointment and opposition to this just as aggressively as we do.
So thank you. I'm glad you raised that, and I do want to come back and focus squarely on some more of the U.S. dimensions on this going forward, what could be done and what it might mean for us. But I'd be remiss if I didn't at least have one question on the ICJ's actions, which I don't want to get lost in all of this. So these are going to be questions from the mouths of babes, given my complete lack of legal education. But South Africa brought a case before the ICJ regarding Israel's conduct in Gaza. But again, to an outside observer like me, it seems, we hear about the ICJ doing things like trying to compel Israel to allow more humanitarian aid into Gaza, or trying to get Israel to stop the Rafah operation. So, Jeff, I'll just a follow-on question. What can the ICJ actually do? Or, what if you're an Israeli decision maker, what does the South African action through the ICJ really mean to you, if any?
Well, first off, again, this is another example of you can't put the toothpaste back in the tube. When the initial decision came out on preliminary measures, the news headline was ICJ finds that it's reasonable to conclude that genocide is occurring. They never made that finding. The president of the court retired and went on BBC and said, we never said that. What we said was that there's a reasonable basis to believe that rights implicated by the Genocide Convention may be at issue, which is why South Africa, under the treaty, has a right to present its case. They haven't even made a finding that there's a genocide going on. What South Africa keeps doing is seeking what are called preliminary measures. That's like a preliminary injunction in a federal court. You file a lawsuit, you believe some other entity is using your trademark, so you want them to stop using it while the lawsuit is pending. So you ask for a preliminary injunction. And to date, the court has refused to grant preliminary measures other than a kind of watered down statement that said to Israel, make sure you keep complying with international law. I mean, that's like a judge saying to you, okay, while the case is pending, don't break the law. Thank you, Your Honor. We'll continue to not break the law. The problem is that this is like the death of 1,000 cuts, that South Africa has elicited a bunch of allies. They keep getting other countries to join their effort. The most hypocritical, I think, recently is Egypt now. Egypt that won't open more border crossings to allow humanitarian, forget letting people out, allow humanitarian aid in. They join in the request for preliminary measures condemning Israel. So it's what it does, I think, for Hamas is it keeps this kind of perception of illegitimacy at the top of the headline list. That's the only weapon. They have two weapons left, the hostages and international condemnation. And so, my prediction is 3 or 4 years from now, the ICJ is going to issue a judgment that says we do not find that there was evidence of genocide in Gaza. So what? Who's going to listen to that 3 or 4 years from now? This is the reality of the information war that's occurring, and it's a difficult war to fight. I think in many ways the IDF is a remarkably effective force in fighting on the battlefield. But how you fight this information campaign, man, I mean, they've been reactive instead of proactive from day one, and they're paying the price for it. And this just contributes more ammunition to the anti-Israel ammo belt by allowing people to say, look how awful they are. An international war crimes prosecutor is going after them without understanding in the slightest all the process, the minimal burdens, what you have to prove. No one will care about that. And that's a real tragedy.
And tragically, but pithily, a summation of a lot of the work that our Gaza Assessment Task Force has done, and that you've been such a steady contributor to, which I'll be sure to follow up at the end on the forthcoming report. But Marc, is there anything you wanted to add on the issue of the ICJ before we move on to the final issue of the U.S. dimension of this?
No, Jonathan, although I share in Jeff's prediction.
So I think with the time we have left, I want to get this will pick up some of the audience Q&A, and also get to the U.S. dimension of this. So we've seen, and this is what I'm about to discuss is much less a legal issue and more a policy and political one. On May 10th, there was a State Department report that said it was reasonable to assess that Israel has violated international humanitarian law in its military operations in Gaza. And then also we've seen the holdups, however brief, of certain weapons systems being transferred from the U.S. to Israel, presumably for political reasons. I guess since we heard this morning the Biden administration's condemnation of this ICC decision, I guess, Marc, I'll ask you first, and this will get to one of the questions from our audience as well. You know, do you see a relation between the Biden administration's increasingly, you know, I'll use my words, overt political pressure on Israel to prematurely terminate operations and using levers to do so? Do you see any connection between that and the ICC decision? Or is there, you know, a lot of dissonance here between, on the one hand, the Biden administration issuing their own assessments that Israel violated international law, but then condemning a court to which we're not a party?
Well, Jonathan, I was a soldier and I am a lawyer. I am not a diplomat. I'm
Yeah.
poorly suited for that by temperament, among other things. But I would say, to the extent that there's a connection, I will say, in my mind, just as a personal view, that the statements and the positions taken most recently by the United States contributed to setting the conditions by which the ICC prosecutor might have felt emboldened or enabled. And I have no information whatsoever that formed part of the basis for his decision. But just so we never have been a party to the Rome Statute. The United States, depending upon the administration, criticizes the ICC, certainly criticizes very much its efforts to look at the conduct of US military personnel, or kind of quietly and behind the scenes, it seems, promotes the objectives of the court and certainly takes opportunities to complement it, while at the same time maintaining its distance, at least as to US military personnel. So there's clearly a political dimension associated with the position that the US takes. And one can only speculate, if the United States had been completely consistent and steadfast in its support of Israel, might that have contributed to the thinking that now is not the right time to pursue an indictment against the Israeli leadership? Only speculation, just as it's speculation that our failure to do that set the conditions for the other result.
So I guess, Jeff, I'll ask sort of a different version of the same question. And again, I have the benefit of, without any legal expertise, I get to sort of ask this with complete innocence. So the State Department report referenced international humanitarian law. Our reports talk about the law of armed conflict. And if our audience goes back and looks at our initial report from 2015, there is some material that discusses this. Are we talking about two sort of separate lines of law here? Is it worthwhile to parse out the differences? Does that matter?
It's ironic, isn't it? The answer to your question is no. It's the exact same body of law. There are two different characterizations for the same body of law. That's the law that historically was known as the laws and customs of war. And then when Colonel Warren and I were young officers, it was the law of war. And then we started calling it the law of armed conflict. The rest of the world kind of embraced the International Committee of the Red Cross view that the appropriate characterization is international humanitarian law. Now, if you're doing academic scholarly work on the subject, or you're being a legal advisor, that is a transparent difference. But again, in terms of the information warfare campaign, it's profoundly significant. I mean, most people today who don't know anything about this hear the words international humanitarian law and think the purpose of the law is primarily humanitarian in nature. My mentor, a guy I replaced in the Pentagon that Colonel Warren knew very well, Hayes Parks, who was an icon in this field, used to say to me, there's nothing humanitarian about war, right? War it's a brutal business. Now, there is a humanitarian prong to the law of war, the entire Geneva tradition, and I'm not discounting that. But the law is not designed just to protect civilians and the wounded and sick. It's designed also to facilitate the ability of armed forces to close with and destroy their enemy through fire and maneuver in the most efficient way possible. The law allows for lots of necessary suffering. It prohibits unnecessary suffering. People don't understand this. And it's unfortunate because it leads to false headlines out of that State Department report. If you read the entire State Department report, it's pretty favorable to Israel and aligns, I would say, almost 95% with the report that Colonel Warren and I are working on that we've spoken about. But the headline is the one sentence that says, we find it's reasonable to assess that there may have been some violations of international law. I defy you to find any major US military campaign where there weren't some violations of international humanitarian law. That's what happens in war. But the report also concludes that the overall compliance by the IDF was unquestioned, and that was not the headline. And part of that is because the focus has shifted from a fair balance between military authority and humanitarian action to one where the expectation is you prioritize humanitarian action and military action is a secondary interest that you can do when you think you can do it. And I think we see that playing out with all the pressure on the IDF not to go into Rafah. I mean, what are they supposed to do? Leave the enemy there? I mean, candidly, it'd be funny if the Prime Minister of Israel said, okay, we'll leave them there. We'll let the United States go get them. But don't drop any bombs and don't use any artillery. And whatever you do, don't kill a civilian. But you guys seem to be able to do this better. Go do it. We couldn't do it. So, I mean, it's illogical in that sense. And part of it has been because of this terminology difference.
Thank you, Professor, for vamping while I was experiencing some technical difficulties there. I certainly appreciate it. So it sort of coming back into the conversation here midstream. With the time we have left, I'd like to get squarely into the U.S. Implications and ramifications of all this. So one thing is sort of Marc, I'll start with you on this. What U.S. policy or what laws do we have codified that can actually protect our citizens or the citizens of our partners and allies against ICC actions? Jeff mentioned having to sort of negotiate exemptions for our forces serving in partner countries, but sort of more broadly going forward, what things does the United States have in its toolkit, or what things might be under consideration?
Well, there's a U.S. statute that prohibits the surrender of U.S. personnel to the court. There's consistent U.S. positions, most recently cited when the ICC purported to investigate and exercise jurisdiction over U.S. soldiers for actions in Afghanistan, where we said we're not going to allow that to happen. I think the ICC, though, is emblematic of a larger move that's going on throughout the world. It's multifaceted, but it has the same objective, and that is, in my view, essentially to neuter military forces and, ironically, to constrain those military forces of the very countries that are committed to adherence to the law of armed conflict in battle. And preeminent among them is the United States. And I think Gaza is a great example, where, as I mentioned, the IDF is operating in a densely populated area, and civilian casualties, especially when the enemy uses civilians as shields, deliberately places its strongholds and weapon systems in civilian places, many of them what we call protected places, schools, mosques, hospitals, does that deliberately. And then there are effects from very carefully tailored, in the case of pre-planned strikes, but effects nonetheless that impact civilian structures and civilian human beings, and that's criticized. There's also a conflation of human rights law and international humanitarian law. And I've been worn down. I now don't say law of war. I seldom say law of armed conflict. I will use international humanitarian law. But I've heard many people in the United States government in very high places talk about violations of human rights law and the obligation of the IDF to follow human rights law. To be sure, there's overlap between international humanitarian law and human rights law, but they're two separate bodies of law. And I think it's fair to say that human rights law doesn't contemplate active hostilities, imposes different duties and obligations, imposes higher standards. And so there's a conflation which essentially would hold operating military forces in the fight to the higher standard of human rights law. And again, that ties one hand behind the back of very effective, efficient, and compliant forces like US forces. And so the ICC is only one part of that.
Thank you. And Jeff, is there anything you wanted to add on this sort of rather weighty question of what this means for the US or what we can do?
Well, I've been editing the Joni's piece on what the U.S. should do. I mean, we do have a law that's designed to protect U.S. service members, and in my view, this is now principally a diplomatic issue, where the president and the Secretary of State again need to go to partner states that are members of the court and encourage them to express their opposition to this. But there's not much that can be done. This is why the United States chose not to join the treaty, because the prosecutor has complete discretion to pursue this charge. And again, the standard for an arrest warrant is not very high. Do I think Benjamin Netanyahu or the Secretary of Defense will be arrested at any point in the future and turned over to The Hague for prosecution? I think it's unlikely. They're going to know where they're at risk of that happening, and they're going to avoid those places. And so, but the problem is that they are now in my view, the two big problems. One, again, the prosecutor has created this perception of immoral equivalency between Israel and Hamas, and that is just absurd. I mean, I'm sorry, it's just legally, operationally, factually absurd. Have the Israelis made mistakes? Probably. Have they had certain government officials who've been bombastic? Certainly. Could they be doing better in places like the West Bank against the violence between Israeli citizens and Palestinians? Unquestionably. But they are facing an existential threat to their existence, and they're not perfect. That doesn't mean they're war criminals. That doesn't mean they're among the worst of the worst in the international community. Hamas, on the other hand, is the worst of the worst in the international community. And there should have been a reticence, a caution to time this thing in a way that suggests equivalency of immorality. That's the first big problem with it. The second big problem with it is that it means that no matter what ends up happening going forward, that condemnation is going to stick. And that's created more of a diplomatic problem for the United States, I think, and again, I'm like Colonel Warren. I was a soldier and a lawyer. I'm not a diplomat. But from a diplomatic perspective now, it's that much harder for the president, the Secretary of Defense, Congress to be wholeheartedly behind Israel in this campaign to eliminate Hamas as a threat to its existence, because it looks like we are now aligning with the outlier. The leadership of the Israeli nation is now in the same category as Vladimir Putin and President Bashir of Sudan. And that is absurd, but that's an image that's going to be hard to shake going forward. And I think that that's really, really unfortunate. I honestly, as I said, I had some confidence that Khan would be credible in the exercise of prosecutorial discretion. And I think this is just terribly disappointing.
Thank you for that, both of you. And I think I would say to our audience, a lot of the issues we've discussed today regarding the ICC and these legal challenges to Israel's operations can be understood and appreciated on a larger scale with the forthcoming Gaza Assessment Task Force report, looking at the legal and operational implications and dimensions of the current conflict in Gaza, which both Colonel Warren and Professor Korn have contributed to mightily. So I would flag everyone to stay tuned for that, which should be coming out very, very soon. I'd like to thank, as always, our two panelists for taking time out of their incredibly busy day to join us and to help illuminate a lot of these issues. And say we look forward to seeing you again on another JINSA webinar soon. Have a great day. Thank you.
Thanks, Jonathan. Bye-bye, sir.
Bye-bye. Bye, Jen.